Good afternoon and welcome to our quarterly virtual estate planning webinar. This marks our 2-year anniversary of starting these 2 webinars on Zoom. And in that time, more than 3,500 of you have signed up for those 7 sessions. And we want to thank you. Incidentally, if you've missed any of those webinars, most of them were recorded and can be viewed by visiting our websites. My name is Cindy Sherrick, and I'm the Director of Donor Relations for the King County Library System Foundation. And I'm pleased to be joined today by my friend and colleague, Kara McDonald, who is the Director of Philanthropy and Planned Giving at the Seattle Public Library Foundation. Before we get started, I want to acknowledge that our libraries are on Indigenous land. These are the traditional and unceded territories of the Coast Salish people, specifically the Duwamish people. The United States government promised hunting and fishing rights and a reservation to the Duwamish people in exchange for more than 54,000 acres of their homeland in the Point Elliott Treaty of 1855. In the 166 years that have passed, the government's promises were never honored. We acknowledge that we continue to occupy Duwamish land.
Thank you, Cindy, and happy 2-year anniversary. I'm going to run through a few items of note for today. First of all our guests are muted and all cameras are off, other than our panelists, to limit background noise and distraction. We are recording today's presentation, and we will send a link to that recording, as well as the slides from our speaker after we wrap up. The recording will then live on our YouTube pages, so you can watch again and share with others if you'd like. If you want to turn on closed captions today, you can click the button at the bottom of your screen. That works to turn them on or off, either way. And then at the end of today's presentation, we'll have time for Q&A with our speaker. And Cindy and I will pose those questions on your behalf. So to ask a question at any point, please use the Q&A button at the bottom of your screen, or it could be at the top if you're using an iPhone or iPad. And we'll get to as many questions as we can during that Q&A at the end. You'll also see a chat function, and some of our staff is going to be moderating that. So if you run into any technical difficulties, use that chat feature and they'll be there to help you with assistance. And finally, when you sign off today, you're going to be prompted to take a quick survey about your experience. So please take a few minutes to complete this. It's a very short survey, but it's really important to us, and it helps how we shape our future webinars like this. And to sweeten the deal, everyone who completes the survey will be entered into a drawing to win one of 2 prizes, bags filled with books. So who doesn't love that?
Right. I'm going to tell you a little about our foundations now, but I promise to keep it short so we can get back into this great presentation. If you come away with anything today from Kara and me, we want you to know that both of our foundations support library programs that go beyond what public funding alone supports. And since this is a webinar about estate planning, it's worth noting that some of the most generous and transformational gifts to our organizations have come in the form of bequests. Foundation funding was especially important to both of us when our libraries were closed during the pandemic. Foundation dollars allowed our libraries to regroup and come up with new ways and programs to serve the public from a safe distance. We're thrilled that both of our libraries have reopened all of our libraries and that in-person events are starting again.
And today's speaker, I'm excited to share with you. His name is James McBain, and he comes to us from US Bank Private Wealth Management. And I'll invite James to turn on his camera and unmute himself and join us here on the Zoom screen. James is a senior wealth strategist, and he spent much of his career practicing law before joining the financial services industry in 2018. He's got a lot of wonderful knowledge to share with you today. So Cindy and I are going to say farewell for now, and we'll let James take it away.
Cindy and Kara, thank you so much for that kind introduction. As I was watching some of the credits roll, just as I was waiting, I did see the one that said, using your will to leave a bequest to the library foundations is a really powerful way to advance their missions. And it's so true. Estate planning is a big part of supporting the libraries, and I really encourage folks to take some time after this, or when you're looking at your will, to figure out good ways that you can help support the libraries that have done so much for our communities. So let me share my screen. I want to show you my presentation about organizing and getting organized. And I think this is a good topic. I know last time you spent some time on, hang on just a moment. You spent some time on estate planning as a whole, learning about estate documents and learning about the important things that you really need to do as part of putting your estate together. And so I want to spend my time today really going through what you need to do to be organized. So once you have your will and you've signed your will and your trust and your power of attorney, the types of things that you need to do or should do after that to make sure that everything fits together. My experience in law practice really proved to me that the planning process is ongoing. It doesn't end once you've signed the will or signed your trust. It doesn't end once you've spoken with the lawyer or even put the documents away. It's an ongoing process that really does require that you spend some time staying organized, knowing how your accounts are titled, knowing how your beneficiaries are named, and things of that nature. So just as a quick summary of what I want to talk about today, I want to start with a background as to what's included in an estate plan. And I know in the last session you went through some of the specifics of what an estate plan looks like, but I just want to ground everybody so that we're on the same page and so that I don't use terminology that's confusing. Well, might be confusing, but hopefully less so if I at least can tell you where I'm coming from. Then after the background, I want to talk about some organizational issues that arise in an estate plan. Things that I saw when I was in law practice, things that I see here at the bank that really kind of show up that I just want you to be mindful of. And some of these things, it's kind of a catch-all. I've put out some things that I just want you to be thinking about and be aware of as you're doing this process. I then do want to spend a little bit of time on estate settlement or probate, that time following death when the whole goal is to put things in order and follow your wishes. And I think it's useful just to have a quick summary of what that looks like and what's important, and talk a little bit about that kind of issues and what the process is like. I then want to spend a little bit of time on record retention. And we get asked a lot of questions. How long should I keep a document? Should I scan it and save it virtually? What types of things should I do? And I just want to spend a few minutes on that, in part because I'm not sure that's talked about enough by lawyers and accountants. And I just figured it'd be a good idea if we spent some time on that. I do want to talk a little bit about charitable giving. I think any presentation that I do about estate planning includes at least a mention of charitable things people can do during lifetime or at death that'll just hopefully allow you to carry out some of your wishes. And because this is for the libraries, I want to at least point out a couple more research materials or books you can look at if you're interested. So let's talk a little bit about some basic terminology. So estate planning is usually thought of as doing my will. So let me back up. An estate is everything that a person owns. Their tangible property, the things they can touch around their house, their real property, the house or other property that they own, that's real estate, and then everything else, their bank accounts, brokerage accounts, savings accounts, anything of that nature are all considered part of a person's estate. Their will is the legal document that directs where their estate is to go upon death. And the will names an executor or a personal representative, the fiduciary, the person who is supposed to follow the terms of that will and make sure that the property passes as the person intended. The will also names a guardian if there are minor children or even adults who are have a guardian appointed for them, where it's an important part of the process in having another fiduciary appointed to take care of somebody who's either a minor or is incapacitated. Like I said, I'll mention probate a little bit. And probate is really the process of transferring property at death pursuant to a will. Now, that's a scary term for a lot of people. They always want to avoid probate, or probate is something that takes too long or is very expensive. And I want to demystify a little bit of that today and explain that certainly in our state, at least here in Washington, probate is not that hard. And it really is in many ways kind of a do-it-yourself process for the person that you've appointed in your will. I do want to talk a little bit as to what a trust is. So a trust in simple terms is just an agreement between three people: a grantor, the person who creates the trust; the trustee, who's the person who holds property and manages for somebody else; that third party, the beneficiary. So that agreement just memorializes the terms that those three parties have all agreed upon, or at least are going to be subject to going forward. A trust can be done during lifetime to own property, or it can arise at death, a so-called testamentary trust. So of those two different types, people often think about their estate is going to go into a trust following their death and be held for somebody, either because the person is young or might need help managing assets, or for tax purposes. Or they could create a trust during lifetime. want to help a child or a family member with educational expenses, or to help them buy a home or something. And the idea is the funds should be managed by a third party, like an institution, like US Bank, or by a family friend or somebody else who would take care of this beneficiary. And then I want to spend just a minute mentioning powers of attorney. I feel so strongly about this one. This, in many ways, is the simplest part of putting together an estate plan, is designating somebody as a power of attorney, but it might be the most important. Because much as though I said probate is fairly easy in Washington, our guardianship, the process of appointing someone to manage affairs for a living person, is not simple. And it does require an ongoing maintenance and court supervision. Powers of attorney, hopefully, if drafted properly and effectively, get people around that, and also allow someone to make healthcare decisions, those critical decisions if someone's incapacitated and needs help consenting to treatment or surgery or what have you. So those are the documents. That's kind of the background, is the terminology that I want us all to be on the same page about. The documents that arise out of this are a will, a separate one typically for each spouse for a married couple, a trust, which might hold assets either for a long period of time or during a specified period, like when a child is a minor, powers of attorney that might be for financial or medical decisions, a healthcare directive, which is Washington's form end-of-life document, often referred to as a living will, because in Washington, it's the document that says if you're diagnosed in a permanent unconscious condition and life-sustaining treatment would only prolong the process of death, you request that it be withheld or withdrawn, and then you can decide whether you want food and water. That's our healthcare directive. People also do burial or cremation instructions to designate where they want their remains. Also, two other types of documents related to property. One is a community property agreement, still fairly popular in Washington, where people will designate all of their property as community or carve some things out as separate property, and then provide potentially that they might pass to a surviving spouse on the death first. And the last one is the beneficiary designation. And this is for non-probate property. I'll come back to that a little bit later, which is a 401k or life insurance. But those beneficiary designations are very important and very powerful. And we'll talk a little bit about why they apply. So that's the terminology. Those are the documents. Let's move forward and talk about getting organized. But first, let me do a quick brief on community property. We are a community property state. And what community property means is that property earned by spouses during a marriage is presumed to be community. That means owned 50-50 by both spouses, regardless of who the earning spouse is. Unless there's a prenuptial agreement that says otherwise, that is our presumption. Now, property received during marriage as a gift or an inheritance is presumed to be separate property. That the spouse who receives that can take that as his or her own because it was not earned during the marriage, it was just received by a gift or an inheritance. Now, spouses can convert property as community or separate by agreement, and they typically need a written agreement to do that. That would designate a certain specific asset is to be separate, or potentially an asset received in an inheritance is to be treated as community. And that should be memorialized in a formal document and potentially even filed with the county recorder's office to put others on notice as to whether it's separate or community. Parties can also commingle property, and this happens frequently, that after someone passes away and they leave money to a child, that child may commingle it by putting it into joint name with the child's spouse. And they're free to do that. It does change the nature of that property. It could cause that separate property to become community by virtue of commingling. So that's a real high-level summary of what the rules of community property are in Washington. There are other community property states like Idaho, California, Nevada, Arizona, but some states like Oregon do not follow this. And if you live in Oregon, the rules are different, and the property generally follows the spouse who earned it. And then if there's a dissolution or on death, the titling on those accounts is actually very important. So that's some of our background. State law prescribes, here's what the rules are as to community property. So that dovetails a little bit with this first issue I want to bring up in the estate plan, which is how assets get titled. So I just said that assets earned during a marriage are presumed to be community property. Well, what if they go into an account that only has one spouse's name on it? Does that change things? Well, in general, no, it doesn't. That's still a community asset, unless there's been action by a spouse to keep it as separate property and it's acknowledged by the other spouse. So one needs to be careful on the titling as to matching it up with community property. For most spouses, when they create an account during lifetime, they might add things like joint with right of survivorship, So a married couple might have an account that has husband's name, wife's name, and it says JTWROS, or joint with right of survivorship. And what that means is on the death of one or the other, all of the assets in the account pass to the surviving joint tenant. Regardless of what the will says, regardless of what other documents say, that titling on that account overrides those other documents. So it's very important to pay attention to how an account might be titled with that right of survivorship on it. Certain other accounts, like retirement plans or life insurance, have specific dispositions for the accounts, where a 401k might have a beneficiary named to say on the death of the 401k owner, the employee, it'll pass to the spouse. And again, no will is required for that to pass. It passes merely following the death of that participant in the plan and passes to the beneficiary. Same thing with life insurance. Someone buys a life insurance policy. They might be the insured under the insurance. They might also be the owner, but they'll name a beneficiary as to who is to receive the proceeds on the death of the insured. So those specific accounts with those beneficiaries really do trump or override a will. They go directly to the person named in that beneficiary designation, regardless of a will, regardless of a trust. So it's something to be very, very mindful of. Clients frequently have a lot of time spent and a lot of care taken in drafting their wills and having a trust that might receive assets or have specific dispositions to children or other family members. And yet if their account says it's going to go either by beneficiary designation or right of survivorship, well, that's where the account's going to go. So this joint with right of survivorship, I've had the question frequently that in some way overrides community property, and it does not. Washington is a community property state. The fact that the assets in there were community and owned by the two spouses, that right of survivorship is just saying where it goes on death. It doesn't change the character of the property that was there. It's still community. That's important for income tax purposes because in Washington, because assets are community property, on the death of one spouse, the basis, the tax basis on any of those community assets are reset to the fair market value as of the date of death of one spouse. So that community benefit is still there, and the joint with right of survivorship does not change that. Two other big issues that I want to bring up that are organizational issues in an estate plan really do relate to incapacity as the first one. And this is so difficult, and we're seeing this happen with increasing frequency with folks who are struggling with mental health issues, Alzheimer's and dementia especially, that hopefully they have a power of attorney and they've named somebody to make decisions for them, but that person may or may not know which assets are there, what accounts are to be used. And this trending in terms of on one day able and fully acting on all of their accounts, transitioning to the following time when they're losing this capacity can be very difficult for the person named in the power of attorney. My recommendation there, folks should make a list, take an inventory of assets and make sure that you know in the event of incapacity, here's who the agent or the person acting under the power of attorney, here's where the accounts are, and here's how they're going to be able to act. So incapacity is so important. Again, just because the document says, I'm the principal, I name my spouse as my agent, that person still needs to know where the accounts are and how they're going to be able to act to take care of the incapacitated principal. The second one I'm asked about frequently is someone's digital life, their online life, whether it's their social media accounts, whether it's even something fairly simple like online accounts and bill pay and online passwords. This is another one. I feel very old-fashioned saying it, but it's really important. Write it down. Maybe not all the passwords, but at least give the family members or the people who are going to act in the event of incapacity or death, at least a sense of where to find the accounts, to know where they are, to know what the passwords are, to know if money is going in or if there's automatic bill pay out from an account, at least to find out where it is. In the old days when people first were starting to do online bill pay, we had a very difficult time after someone passed away to try to get access to these accounts. Things have improved in the 20-some years since I had seen my first situation of online, and it's easier to get access, but it's still not simple. We really do want to make sure that our fiduciaries, whether that's our personal representative or executor of an estate, or whether it's a trustee of the trust, know where to find things in order to care for the people that we're naming in our plan. So again, make a list. I don't mean to sound like a broken record. Same thing with social media accounts. Things like LinkedIn, Facebook, Twitter, Instagram. We all have passwords for those in order to get into those accounts. Not that someone wants to be posting a lot after someone passes away, but it's still important to know if you have anything that you want to inform people that something's happened or try to figure out how to respond to messages. Giving somebody where your access to your password is would be helpful. Something I didn't put on the slides, and I probably should have, relates to non-fungible tokens. So online purchases of digital information that might be stored in a wallet or a locker online. And more people are doing this, whether it's through artwork that they buy or any other collectibles or things of that nature online. It's important to want to help out beneficiaries by naming, here's how you access that, here's how you find it. Again, a lot of this is really a process of taking an inventory of one's assets, and that's such an important part of organizing your estate. You've done the will, you've done the powers of attorney, now that inventory is really going to be our guide. So what do you do with all these documents? You've signed a will, you've signed a trust, you've signed a power of attorney. A lot of times people feel so good when they've done that, they then want to know, where should I put it? Should I put it in a safe deposit box? Should I put it in my desk drawer at home? What should I do? Well, it's important to know where the original will would be if we have to open a probate, because that has to be produced and submitted to the court. We need the original in order to do that. More often than not, when I was in law practice, clients would leave their will and their estate planning documents with me to be kept in our firm's will safe. It was secure, they knew how to access it, and it seemed like that was probably the best way to go. Some people like to put them in a safe deposit box, and I think that's okay. What I worry about is accessing the will after the death of potentially both spouses who might have had the only two keys for the box. So when the kids would go to try to retrieve the will, if they don't have access to the safe deposit box, they might need a court order to go get it. And to get that order, someone's going to have to go in front of a judge and say, we really think the will's in the box. Would you please order us to have the box drilled? And boy, I sure hope it's in there. I'd hate to have to go back to the judge again and say, well, it wasn't there. Here's where we think it might be. So the safe deposit box is a tricky one unless a child has a key or at least the ability to access the box as well. Some people do want to keep them at home and have a safe. And again, I think that's fine. Just let's make sure we know who would be able to access it in the event of death. Should we give a copy of wills and trusts and things to our fiduciaries? I think that's generally a good idea because we want them to know, especially this power of attorney in the event of a sudden incapacity. We want to be able to pay the incapacitated person's bills. But the risk that we have is that if the fiduciaries are also beneficiaries, do we really want them to see everything that's here? Are they going to have some expectations that they develop? Especially because most of these documents are changeable. So if you want to change it in the future, are you going to have to retrieve it and get it back from the person where you gave them a copy? That's why I say maybe not on those. I think it's important just to be mindful of what are your priorities. Many times people would want to let their children or their other family members know they had done a will, and here was the name of the lawyer's office where the will was. I think that's a good idea. If someone feels very settled that husband and wife have done their estate, everything's going equally to the two kids, they feel comfortable, that's how it's always going to be, then they certainly could share them if they felt that was appropriate. Certainly more of a client than a lawyer decision, but it's certainly something I want you to think about because you shouldn't just automatically assume you want to hand it off to them so that they know. Oftentimes that leads to questions that you really might not want to be talking about. I do think wills should be updated or at least reviewed every few years. And it's not just because of tax changes or not just because you move to a different state. The biggest priorities are when your family, your wealth, or your goals change. Now, if you do move to a different state, it's worth at least inquiring of a lawyer or doing an online search and finding out, are there specific things that one should consider? Does that new state have separate living will form or different power of attorney forms that are different from, say, if you were living in Washington and moved somewhere else? It's worth being aware of what the differences might be and considering whether you need to update, but it's not automatic. It's not as though you move and you feel like you must do this right away. All states are going to respect a will properly executed in another state. So it's not as though you're going to be going without. It's just that potentially there are things you might want to change. And I tend to think the most important ones relate to healthcare, whether that's a healthcare power of attorney or directive of some kind. So those are the reasons. I often think when I say update, I really want clients to at least look at what they've done before, see if they're comfortable with the people that they've named. And it's almost always about the people. Who have you named as your power of attorney? who's listed as the personal representative or the trustee, who's the guardian for the children. Those are really the big decisions and things that if there's going to be a change, it probably relates to that. Now, there are always proposals to make tax changes. And sometimes it's worth talking with your lawyer or your CPA about that as well. But I'd start with the big ones as to the family, the goals, or the wealth. I said I was going to talk a little bit about estate settlement, and that's the probate or the post-death process of settling of someone's estate. The early steps in that are getting kind of the big three here, which are getting the death certificates, calling Social Security and stopping any of the payments or allowing the survivor to elect the payments, and then securing the home, making sure that the real property and any of the contents of the home are secure. Then it's time to find the will or any of the estate documents and review how many assets might be titled. If someone's done a good job, has left you the inventory, you can at least get a start on how are these things owned and what changes are we going to need to make through a probate. You'll also want to find out if you even need a probate. If things are titled so that they have beneficiaries on them, then there might not even be a need for one, because probate is just changing the ownership from a deceased person to somebody as they've provided in their will. And if the deceased person during lifetime already did that by having joint with right of survivorship, or maybe payable on death or transfer on death on accounts, or even a transfer on death deed on a home, along with beneficiary designations on retirement plans and life insurance, there might not even be a need for probate if you've done good titling. But it's worth talking with the lawyer when you go through the process of putting the estate plan together to make sure the documents and the titling are properly harmonized. Then meet with the lawyer. Bring the documents, have a chance to go in with an inventory and at least know here are the priority items we're going to need to talk to the lawyer about. Now, the probate process itself, so generally the personal representative named in the will hires an attorney who prepares documents for the court to sign, and a petition and then an order for the court to sign. They produce the original will, and then the person is named as the personal representative of the estate. Now, at that point in time, that's really the most important thing that happens, is getting that person appointed and named as the personal representative is how things get started. And once the person is named and appointed, they have the ability to start changing title to any of the assets. The process is very much a do-it-yourself process. And if properly appointed, our personal representative of the estate or our executor has what are called non-intervention powers, which means the court's not going to intervene unless there's a reason to intervene. The person appointed is going to be transferring assets, retitling things, and taking all of the actions without having to have a lot of court hearings. It's a very productive process, and it's a lot less expensive than in many states. Now, where does it apply? It applies to things that are in the name of the deceased person. So again, these retirement plan assets, life insurance, something that says transfer on death or joint tenant with right of survivorship, do not go through probate because they've already been designated. So it could be a fairly limited process. The purpose of it is to gather up the person's assets, to gather up any of their debts and settle everything, so that once probate is over, then all the assets will be in the name of the person or persons named or trusts named in the estate plan. And that executor or personal representative will be discharged and won't have to do any more and will be off the hook. All the debts will be settled, all the assets will be transferred. That's what the process is, and that's what it's supposed to do. People often would ask me, how long does this take? And it's a very unsatisfying answer to say, well, it really depends, but it does. It depends on the complexity of the estate, the size of the estate. An estate over $2.2 million in Washington is going to require the filing of a Washington state estate tax return. An estate over $12,060,000 is going to require the filing of a federal estate tax return, which usually extends the process. Those are due 9 months from date of death. And then it usually takes the Department of Revenue or the IRS about a year to review them. And if all goes well, potentially close to that 2-year mark on a larger estate, you can start the settlement process and distribution. On a smaller estate where you're not waiting on the IRS or the Department of Revenue, you should be able to settle much sooner than that, hopefully within 5 or 6 months, at least starting. So these non-probate assets I talked about, 401k, life insurance, or some of these specific titles, do not go through probate and actually are a very smooth transfer, generally with a death certificate and the information for the beneficiary, name and address, social security number, and the like to get things retitled. So I said early on I would talk about record retention. And as I put this table together, I realized so many things said permanent or 7 years. It made me think, wow, we're all going to be holding a lot of paper for a long time. That doesn't sound very appealing, but the problem is many of these things we need to hold long term. I start off with gift or estate tax returns that are permanent because you want to be holding on to those, showing what the tax basis of assets would be if they're later sold. We look at a lot of things related to your income tax return, and the general rule there is you need to hold for up to 7 years. The reason for that, there's a statute of limitations at 3 years, another one at 6 if there's a significant omission, and then you hold for a year after that generally. That's where the 7 comes from. The other things like bank slips and deposits might be shorter than that, and even some of the credit card or other statements, I've always felt like those could be discarded earlier unless you've got proof of a warranty purchase or some other reason to demonstrate which card you used or how it's purchased. Things related to a home, you want to hold on to for the duration of the home ownership. Again, many of these things really do relate to taxes. What's your tax basis, your purchase price, any of your improvements, so that if it's later sold, we can properly calculate what any capital gain would be. Things related to paying off loans, I typically always tell people permanent, you always want to prove that you've paid something off. There's no real tag where you would say at a certain point you're clear of that. I think it's a good thing to hold on to. Same with any documents related to birth certificates, divorces, death certificates, those are typically held permanently as well. So I hope this is a useful chart or at least a starting point. And on some of these things, your mileage may vary. But I think in general, it gives you a sense on many of these things need to be held for quite a long time, and it's useful to do that. You want to be able to prove, again, to the IRS what you paid, what your cost basis might be, in order to properly calculate what your tax would be. So you've planned your estate, you've made sure that you kept the documentation of what you needed, you've got things properly titled. Now it's time to think about charity. And I do want to spend some time on this because I think it's a good thing to think about during lifetime as well as at death. But certainly during lifetime, as we've seen, especially during the pandemic, how beneficial it's been to our charities that we so treasure, that people have made outright gifts and have really helped them along. Some of these are fairly simple, and you've probably heard them before. I think they bear repeating. Charitable giving, the basics are really where I think people should start and spend some time. Outright gifts, just writing a check. Making a gift of appreciated securities. I really hope people take advantage of this one. Giving appreciated stock, if you've got Amazon or Microsoft or Costco or something, that what you paid for it is quite a bit less than what it's worth. And if you sold it, you'd have a big capital gain. That's a great thing to give to a charity who can sell it and then not have to pay the capital gains tax. And you don't either. And you typically get the charitable deduction equal to the fair market value of the stock that you've donated. So I stress that one. When people look in November and December to think about charitable giving, and they oftentimes just say, well, I'll just write a check, take a look at your brokerage statement. See if you've got something appreciated. It's very easy to do a gift of stock, and the library is very happy to have it. Now, qualified charitable distributions from an IRA are also a very, very popular way of giving. And I'm seeing this one frequently for folks who are over 72, or even a few years ago, 70 and a half was the age where they could start doing it. Or you could give up to $100,000 a year out of your required minimum distribution directly from the IRA to the charity. Now, why is that beneficial? It's beneficial because then it's not included as part of your adjusted gross income for income tax purposes. Well, that seems like the same thing. But then if you turn around and make a gift of that, you get a deduction for it. A deduction is not as good as though the amount was not included in the income, first of all. So it's a better gift if it goes directly from the IRA, not included in your gross income, and not having to take a deduction against it. It's just more tax efficient. The other things that I know a lot of charities rely on, bequests and wills and trusts. Over time, most charities get a significant portion of their funds through legacy gifts, either through a will or through a trust. And they typically, because death happens every year, they're typically a fairly steady way of providing support, including in your estate plan that there's going to be a gift. A lot of charities are seeing this as a fairly predictable way of at least having ongoing contributions, either through a will or a trust. And a beneficiary designation on a retirement plan is also a really wonderful way to make a gift, because that retirement asset, if it's not a Roth, is loaded with income tax. And if you name a charity as the beneficiary of that retirement account, then the full amount goes to the charity and they don't owe the income tax on it because they're a charity, as opposed to leaving it to a child or a family member who would have to pay ordinary income tax on the amount distributed. So these are powerful techniques. I really recommend talk to your tax advisor. If you're wanting to do a gift, this is I think the simplest and best type of gift planning that you can do. A lot of people want to talk about charitable trusts, donor advised funds and foundations and things of that nature. And that's helpful. And those are really wonderful if that's what somebody wants to do. But I never want to forget the most straightforward ways of going, which are the outright gifts, the securities, and the IRAs. They're just so very important and such a critical part of estate planning. Something we should all think about every year is how we want to do this. Learning more. So I think at the last session, you had a good summary of estate planning, and then mine is more about organizational issues, and it's a bit of a hodgepodge of things that come up, but hopefully you found it useful. I did want to point to a couple different books that are out there that talk about some of the things I was talking about today. Melanie Cullen's book on getting your records organized, really important. It's so helpful to your family members to be organized enough that if they have to serve as an executor or personal representative, they can find everything and carry out your wishes. Sally Herm's book on a checklist for the family, another good way of doing it. These things all kind of fit around this idea of having an asset inventory. You don't have to give it to the lawyer or the CPA, but have it. Maybe you keep it with a copy of the will or the trust that you have in the desk drawer at home. It at least is what I've referred to before as the breadcrumbs that help that personal representative or trustee figure out where things are in order to carry out what your wishes are. And then Harry Margolis's book on getting your ducks in a row, a little dated by calling it the baby boomers guide, because it really applies to all of us, but it really is, again, all about getting organized and staying organized. So I hope that's been helpful. These organizational things are ongoing, so spend some time. When you open up a new account somewhere, think about how it ought to be titled. When you look at your wills, think about, do the titles fit? Do the beneficiary designations fit? Does everything kind of fit in one cohesive piece? And if you do that, I think you'll have a much more successful experience than if you hadn't thought through some of the organizational issues and are just left with the documents that you did. So that's what I have. I thank you for your time, and I look forward to questions.
Well, thank you so much, James. That was really, really great. We had some really great feedback in the chat and some great questions. I'm going to start off with a question what we received in advance from Pat, and she asks, what happens to my bank accounts after my passing if they are not specifically named in my will?
That's a great question. And a lot of people would ask that one because they want to make sure that things go where they want them to go. So if you haven't specifically listed in the will where the asset goes, for instance, if you had said in the will that you wanted to designate your home to somebody, well, that's where it would go. But if you haven't named it, it's part of what's referred to as the residue of your estate, the remainder, the assets after any of these specific gifts. And for most people, that's really the bulk of their assets. Most people are not listing asset by asset where things go, largely because values on things change. They might not have that asset anymore if they list a home or an account and they change things up. So it falls as part of that residue. And a well-drafted will usually will say, I leave the residue of my estate equally to my children or a trust for my children or what have you. So it falls into the residue, Cindy. That's where it would end up. And it would be distributed according to the will as to where that residuary amount goes.
Thank you. I'm going to just make one quick note is that we will be following up with everyone with copies of the slides as well as a link to this recording.
You're in high demand, James. This is good. So another question we got here is from someone who is a solo aging person with no heirs. And they ask, if you want all assets, including investments, personal property, and real estate, to go to several different charities, what do I need besides a will?
Great question there too. You could do it by a will, and the will could just say in your residue, you're going to leave either a percentage or you're going to leave a specific dollar amount. You're going to come through all the charities. Just as an example, if you had 6 charities that you wanted to benefit equally, you might say that I leave the residue of my estate to these 6 charities in equal shares. Or you might say, I want to leave one of them $100,000 for scholarships, and one of them is going to get, say, $50,000 for enhancing their book collection. If you have specific things that you want to limit out, you can do it that way. Now, the most organizational thing we really could do is create a trust, a revocable trust during your lifetime, but one that says, on my death, here's where my assets are going to go. And if the accounts were titled in the name of the trust during your lifetime, there would not be a probate then following your death. It would go according to the trust amongst the different charities. The real key things to think about when you don't have family members or anybody else is who would be that trustee of the trust or personal representative of the estate? And then how do you want to divide things up? If you know there are charities or institutions you want to support, are they dollar amount gifts? If they are, that's okay, but make sure at least somebody's going to get the residue. I've always wondered about, I'm not a math major, but many people would want to say, okay, my estate today is $500,000, so all I need to do is make 5 $100,000 gifts. Well, that sounds good, but what if the estate grows and it's now $1 million? Who gets what's left? What if it goes down? Does everybody share and share alike in the decline? So oftentimes people prefer to say they give a percentage of the estate, say, to each of the charities that are going to be named, unless there's a dollar amount that they're trying to satisfy. Kara, I hope that answers the question.
Yes, thank you. Thank you. Cindy, do you want to ask another one?
Sure. Another question we received in advance is, what is the best way to leave my house and car to my sons?
Great question. I mean, a car is that, let's start with a car because that's actually easier. Typically you'll have that in your name, and there's a form that you fill out with the Department of Licensing, or that your heirs would fill out saying they're the ones who are entitled to receive the car. It's quite straightforward. A car is tangible personal property. So you can even make a handwritten list that says, I want to leave my car to somebody, as long as your will says I can make such a list. Washington law allows it, but we really prefer that the will say, I'm allowing that to happen. Let me start from the beginning. I think your best way to do it is either to do a will that says I leave my home here and I leave by list any other tangible personal property. Well, that works quite well. Another suggestion is even on the home is you can do what's called a transfer on death deed. Those are fairly new in Washington, but it's a nice way of having a deed that says I own the home and on my death it's going to go to my son. So that's certainly another way that you could do it that does not require a probate because the deed itself designates where it's going to go. And then he can go into the Department of Licensing following your death and fill out the DOL form that says he's the one entitled to receive the vehicle. So those are pretty straightforward. Do be aware, for a lot of people who ask questions about those, if you've got bank accounts, if you have other assets, you still should probably have a will that at least picks up where these things are going to go.
Thank you.
Great. Here's another question from one of our attendees. What to do if my joint tenants with right of survivorship and beneficiary designations for my accounts, IRA, and Roth total over the Washington estate threshold limit?
What should you do with that? Well, it really depends. A great thing to do would be leave a portion of it to charity so that you wouldn't have to pay any tax. And I do think the Seattle Public Library Foundation and the King County Library Foundation are really good choices. It really depends what you're trying to accomplish. So maybe you're trying to get as much to beneficiaries as possible. The Washington estate tax is a 10% rate on the amounts over that first $2,193,000. So it's only 10%. Maybe you're okay. The other 90 is going to go to the family member or whomever. A lot of people do look to charity and say they want to either do a will that by formula says I leave as much as I can to my family members without any state of Washington estate tax, and anything in excess of that will go to the charity. So a formula like that will essentially eliminate any taxation on the estate by making a charitable gift on the amount over the exempt amount. But it's really kind of up to you as to what you want to focus on. So many people worry about the tax, and I just want to remind you, the tax, it's important and it's worth thinking about, but think about what the rate is. And again, if you're still wanting to get 90 cents on the dollar to somebody and only have that 10 cents on the dollar tax, that's still a possibility. And many people feel that that's just part of the process of transmitting wealth. If you feel strongly and don't want to pay the tax, think about charity. Or Washington does not have a gift tax. It's a little bit surprising. The federal system has a gift and an estate tax, so you can either make gifts during life or pass assets at death. Doesn't really make any difference. Depends on the timing, of course, but it's the same exempt amount for federal purposes. We don't have a gift tax in Washington. So if you made gifts during lifetime, they're not counting against the Washington exemption amount. That $2,193,000 is still there for assets on death. So one option is go ahead and start making gifts out of that joint tenancy account. And then that'll reduce the size of the estate underneath the exemption. That's just some ideas. Charity, gifts, those are how I'd start.
Great. Thank you, James. We have two questions here having to do with retention of files and paperwork, it seems. So one is, how long do brokerage firms retain records related to individual accounts? And then another one is, if you sold a house more than 7 years ago, is it still important to keep payoff and sale documents retained?
So those are great questions. Let me start with the house first, and then hopefully I'll remember what the first part of the question is. And if I don't, hopefully Kara can refresh me. I guess as age is creeping upon me, I'm not remembering quite so well. With house payoffs, I really do like people to keep that and hold on to that. And there's not a really good legal reason. Once you've gotten the notice of payoff, you're free and clear, you're good to go. You really don't need to keep it. But the reason I recommend that people keep them is maybe if you need to prove that someday, it's sure nicer to be able to hold that one up and say, this said I paid it off, than not having that. And I know not all of us want to keep paper around, so at least scan it or take a picture and save it. I think it's important to keep payoff records. I personally just wouldn't want to shred that or let that one go. Homes, especially the 7-year period, if you've sold it, reported any of the gain on the tax return, you're right. After that 7-year period, we're not looking at taxes. It's just a question of liability. And there are statutes of limitation under Washington law that says they can't come back at you under a contract. But a statute of limitations usually has to be pled in litigation. And once you get to litigation, you're already paying a lawyer and it's already unpleasant. Or if you're able to hold it up and say, no, I paid it off, I think that's the best answer. So I think that was part two. Part one was how long I think I got this, Kara. How long do brokerage firms keep any of these documents? Well, they generally are keeping any of the information related to a purchase of a security, as long as you hold the security, certainly. And many of them do have record retention that will keep it at least 3 to 7 years afterward. Now, most brokerage, I can't speak to all of them, but the ones that I dealt with over the years would keep them for 3 years after they would sell a security. So if somebody needed it in the course of a probate to go prove what the value was, they could obtain it. I will say it's not easy and it's not predictable. And again, I work in financial services, but not everybody does, well, not everybody does as great a job as US Bank does, but there are differences one to the next in terms of what their record retention is. The best thing you can do is ask your provider as to how long they might keep things. Most of them are keeping them at least electronically, at least 3 years following the sale, if not up to that 7 years.
Nicely done. Thank you, James. I'll ask Cindy if you want to read another one of those questions.
Sure. How about this one? How do I exclude someone, an ex or a divorced child-in-law, from my estate?
Oh, that's a great question. And Cindy, I got asked that question frequently when I was in law practice. Now, do understand, first of all, the only people that you need to exclude from taking an estate, need to exclude, are going to be people who would take in the absence of a will. So Washington has what are referred to as laws of dissent and distribution, as do most states. And those are the default rules. If you don't do a will, here's where your assets go. So typically the only people you need to exclude would be those essentially heirs at law or takers in default, delightful legal terms, of the folks who would receive your estate if you passed and didn't have a will designating where it goes. So if you want to exclude a spouse, again, difficult as to community property, children or descendants, then it needs to be written in the will. I acknowledge this is my grandchild and I intentionally omit him or her from taking, or son or whomever you want. Now, the question was about exes. So if a son had a spouse or was married and we want to make sure she doesn't take because they had a divorce, well, we didn't have to name her because she didn't have any legal right to take. She was never a blood descendant. She was never anybody who would have been an heir at law. But many people still want to list in the will, my intent is that she will not receive a part of the estate. And I think that that's fine to do because, again, we're always trying to figure out what your intent is. Anytime there's litigation, that's trust or estate related litigation, it's going to come up. What was the person's intent in doing this? So Cindy, if the will says, I intend to exclude, my daughter-in-law, who I didn't like so much anyway, that's a fine thing to include in the will, even though it's not technically necessary. So take comfort, it's not necessary to exclude somebody, whether they're married to your child or an ex-spouse. They're not part of what would be your bloodline under the laws of Dissent and Distribution. So they would not be a taker in the absence of a will. So they don't have to be specifically excluded, but there's no harm in doing it. And many people feel more comfortable, again, with that statement of here's what my intent was to exclude this person. That was kind of long. I'm sorry, Cindy, but that was,
nope, that's perfect. Thank you.
Thank you. Beth asks, what is the easiest way to change a list of charity recipients in a will if the rest of the will still works?
So it's a will. So wills have to be executed with appropriate formality, which in the state of Washington means that you're signing it in front of two witnesses. So if it's in a will and you want to make a change, you need to do what's called a codicil or a new will. So even if you're just adjusting the amount that the charities were going to receive, you really do need to do a new will. Don't cross things out. Don't get your original will and cross out in blue pen and then write blue was for 2022, green was for 2012 or what. No, the lawyer's going to be unhappy. The judge is going to be even less happy. So you really do need to do a codicil to the will, which is an update to it. Now, because those do require also two witnesses, and as we found during COVID, that was tricky for people to make sure they had enough witnesses. A lot of clients were happier naming the charities in a trust, because amending a trust typically just takes the signature of the grantor, the creator of the trust, and then a notary. So it's not a full witnessing process. And a lot of trusts also were able to be done kind of more of a simple notary as opposed to the two witnesses. So consider whether this might be an easier way to go from having a will that lists everything to maybe having a will that leaves things to a trust, and then the trust has the specific distributions amongst the charities. I wish I had a simpler, I wish it was, you had one document, you could refer to it, it would be a naughty or nice list, but it doesn't really work that way for cash gifts.
Got it. There's another question here from Dale about leaving bequests to charities. Does the charity pay taxes, or is it better to make the charity a beneficiary of your IRA?
Well, the charity does not pay taxes so long as it's a 501c3 charity, it's tax exempt. So, but I think Dale's question is getting at a really important and useful point in planning is what is the efficient way to do it? If you could leave the kids $1,000 cash through your estate or $1,000 in an IRA, what's the more efficient gift to the kids? The cash from the estate, because they get the $1,000. If they get the IRA, they're going to have to pay income tax on it. So turning that around for a charity, the more, either way, the charity is going to get, in my example, the $1,000. But the more efficient way to plan for Dale's estate is maybe this is where we want the charity to receive the IRA, because the non-charitable beneficiaries would have to pay income tax on it. I'm a big fan of leaving money from IRAs to charity just to avoid that income tax piece, because the charity doesn't pay income tax when it receives the IRA distribution. So that's how I would approach it. Dale, it's a great question. Because it really does allow you to figure out inside your estate, which is the more efficient way to do it. So, and that's for income tax. This is not even based on, on an exemption amount, because income tax is going to apply to any of us if we've got retirement plan assets that weren't taxed.
Okay, great. We have a question here from Leah. Can you hire someone to be an executor if there are no children or younger relatives?
Leah, yes, you can. Institutions like US Bank are delighted to be executors or personal representatives. And I guess I'm seeing more frequently people are wanting an institution to serve as opposed to a family member. They worry that family members are going to struggle with the process of gathering the assets, giving notice to any of the creditors or any of the family members, making sure all the tax returns get done, and making sure that they've hired a lawyer. The process itself, the probate process, is difficult enough for a lot of families, not just the process, but the emotion that they've lost a family member. They might like an institution to handle it. So you certainly can, and you can hire banks like us. There are independent trust companies or even smaller trust companies that are also solutions. A lot of them are listed either on the Department of Financial Institutions website. So I think that's, it might just be dfi.gov. That'll list out some of the trust companies who can serve, which are Washington-based. Any of us who are national banks are chartered under federal law, so we're not listed there. But any of us, whether it's us or any of the other large banks, can serve as an executor in the estate.
Thank you.
It looks like we only have about 5 minutes left, so I'm going to ask one last question, and then we'll wrap it up for today. I think this is a good question. You touched on storage of passwords and whatnot. Carol asks, what do you think about storing all document copies on the cloud and sharing access codes with your durable power of attorney?
Well, at the risk of indicating that I'm not the most technically sophisticated person in the world, my understanding is cloud storage is becoming more and more common for estate planning documents. There are corporations that are being set up that will help you with that type of management, and you have one password from them, and then you can access all of your documents in the cloud. I did have clients who used, whether it was their iCloud or OneDrive or whatever, for storing their documents and then giving password access to other family members, or writing down the password and giving it to me along with a copy of their personal property list or other documents they wanted me to hold when I was in law practice. I think I need to wake up and be aware of the 21st century, that more and more of this stuff is going to be saved that way. So it probably is a good way to do it. It's ready access for a power of attorney, and I think that that's useful. And I don't mean to keep, this was supposed to be more on your estate, but I don't want to forget the power of attorney one is so very important. I mean, clients frequently, after listening to me talk for a while, say, I'm not so worried, I'll be dead anyway. But with the power of attorney, that's not true. You're still around, and we want to make sure that you're taken care of. So we want access to these things to be easy and to make it so that your bills get paid while you're incapacitated. So I guess short answer, I made a short answer long, is that I think more people are going to be doing it, Cindy. I think cloud storage is going to become more common, is becoming more common already, that people were asking us at the law firm to send, email PDF copies, and they were going to store them, and they were going to put passwords on it and give the password to a colleague or their CPA or somebody else, so that there would be this kind of backup access. And I do support that. I think it's just one more way of having secure access to important documents, whether they're old-fashioned paper, like I like, or whether they're digital versions that are stored in the cloud.
Wonderful. Thank you so much, James. I really sincerely, we're so grateful for your time today and your expertise. We've had so many questions about whether this presentation will be recorded, and the answer is yes, absolutely. We're going to share this with everybody. It will also be available on the Seattle Public Library Foundation's YouTube page immediately after this. So if you need to go there, if you want the information right away while it's fresh, you can rewatch it over there. I also want to thank US Bank Private Wealth Management for just letting you use your time for this and for supporting libraries. Now, as a reminder for everyone, when the webinar ends, you're going to be prompted to take a quick survey. I promise it's very short, and I hope you will fill it out, and we will incentivize you for doing that by entering you into a drawing to win a bag of books from each of our libraries if you do fill that out. So thank you for taking the time to do that. And in addition, look for an email from us again with that recording. We'll share slides, we'll share some more resources, just as a thank you for coming today. And then also keep an eye out for our next webinar, which is planned for August. And finally, I hope you know that a charitable bequest is one of the most meaningful ways that you can support the nonprofits you love, including your library. So if you have any questions or would like to continue this conversation, Cindy and I are here for you. Our contact information will be on the screen shortly. Thank you all for coming, and take care. Thank you.
Thank you, Cindy. Thank you.